I want to highlight this Supreme Court ruling because, as I mentioned in headlines, I mean, it's just this is like soft fascism, and maybe I'm being generous by saying soft. Um, it allows for a specific large subset of federal agents, essentially, really more targeted towards Customs and Border Protection agents, to act with impunity. Mark Joseph Stern wrote this up in Slate. On Wednesday, the Supreme Court abolished individuals' ability to sue Customs and Border Protection agents who violate their constitutional rights. In the process, the conservative supermajority came close to smothering lawsuits against all federal officers who defied the Constitution, granting them near impenetrable immunity. So, I mean, there are tens of thousands of Customs and Border Patrol agents, and already migrants, people crossing the border trying to seek asylum. I mean, you've seen the images. They already face insane abuse. But now the Supreme Court is ruling you're not going to have recourse because this is in the interest of national security, essentially. Wednesday's case, Egbert v. Boll, is the latest and most thorough attack on accountability for federal agents who break the law. The decision arises from a loophole in the federal statute that lets individuals sue law enforcement for damages. This statute authorizes suits against state law enforcement officers who infringe on civil rights. Sheriffs, local cops, highway patrol, all can be sued in federal court for constitutional violations. But the statute does not authorize such suits against law enforcement officers who work for the federal government. The Supreme Court addressed this problem in 1971's Bivens v. 6 Unknown Named Agents of Federal Bureaus of Narcotics, which involved a claim of excessive force against federal agents. And conservatives have been essentially trying to go after this ruling for a long time. The court has insisted that the precedent applies only when the facts of the case are nearly identical to Bivens. So in theory, when federal agents use excessive force, they still can be sued. But if that force takes place in some, quote, new context, with, quote, special factors, aka if it's not essentially identical to the precedent, say some connection to national security, as I mentioned earlier, the suit will fail. And because there is invariably some distinction between two cases, naturally, courts usually had an excuse to toss out Bivens' claims. And so Clarence Thomas basically wrote this up in the Supreme Court and moved the goalposts. He replaced the standard, Stern writes, with an even more stringent one. Judges hearing Bivens' claims, he wrote for the court, should now simply ask whether there is any reason to think that Congress might be better equipped to create a damages remedy. Basically, though, what it comes down to, in this case that was brought, a federal agent allegedly used excessive force against an American citizen on American soil, the precise scenario to which Bivens ostensibly applies. So it did meet that initial criteria that this is the same thing as the precedent. So you should, in theory, if you were acting in good faith as a Supreme Court justice, which we know they're not, they should be identical. But no, Thomas wrote, because the incident occurred so close to Canada, it was on the Canadian border, it has, quote, implications for national security and border security. As a result, greenlighting Boulet's lawsuit would constitute a, quote, judicial intrusion into Congress's policy-making role. So that's where this opens up this massive can of worms. So tens of thousands of Border Patrol agents, since it was involving the Canadian border in this instance, are going to have the ability to act with even more impunity than they do. We saw images of them using reins as whips, essentially. Hey, if that happens to you, you probably don't have any legal recourse based on the Supreme Court.
This is within a 100-mile border exclusion zone, and if you don't know if you're within that border zone, you might want to look at this map here, which is like if you're near any sort of water or coastline, so, you know, the entire coasts, all major cities on the coasts, are all within this, even like the Great Lakes area, which I didn't know that this, it seems bizarre that like Chicago is considered on the border, but it's on the border, I guess.
Yeah. So just another,
yeah,
go on.
Just to say one more thing, it's like this is, you can say well, fascism. This is making border agents an American Gestapo, and it means that if they find a reason to go into your house for whatever reason that they want, that they'll have a legal precedent that they could cite saying, actually, we're just doing this because of national security.
Exactly.